Senator from Anderson, Senator Cash, what purpose do you rise?
If Senator, were you for a question on this point?
Yes, Senator yields.
Senator yields.
All right, so I listened to a lot in the subcommittee as well as the full committee on this. Now, this discussion about preemption and the Controlled Substances Act, I don't recall this at all, so this is new to me, okay? I just did not pick up the nuances of what's being talked about here, although I think it's an important subject. So,
and part of that's probably my fault, Senator from Anderson, in that I've worked on this for so long that I just move on to the things that I think are still, debatable. And so, but I'm going back to kind of first principles here now, and I'm talking about our authority to act, because I want this body to have the benefit of all my thought process throughout the 7 years.
Well, I think that's the place to start. Now, what I think I heard you say is that the Controlled Substances Act, and that's a 1970 bill, correct? Something like that?
71, I believe.
What I've written down here is that it anticipates the states doing something differently than the federal government, or that it provides for the states doing something differently than the federal government. I mean, what was the argument you're making? I heard it. I've just heard this one time, and it's just not sticking. So what is it you're saying?
Okay, so in the Controlled Substances Act itself, okay, 21 U.S. Code Section 903, application of state law, it states as follows: no provision of this subchapter shall be construed as indicating an intent on the part of Congress to occupy the field in which that provision operates, including criminal penalties, to the exclusion of any state law on the same subject matter. Okay, so in regard to the Controlled Substances Act, okay, that's what we're talking about here. It is not the intent of Congress to preempt the field. It expressly declares that it's not preempting the field. It expressly says this cannot be read in such a way so as to interfere to the exclusion of any state law in the same subject matter. Okay, so, but again, as I said to the senator from Charleston, that's express preemption, okay? There's no express preemption, because sometimes Congress does that in their bills. They say, we intend to occupy the field here. And in that case, you know, the supremacy clause of the U.S. Constitution means, okay, the federal law, that's the law. But what you have to do further, though, is look at implied preemption, okay, which means that by the very language of the bill itself, that if you passed a state law that prevented the federal law from being enforced by the federal government, okay, that would be obstacle preemption. Okay, so even in cases where
what?
Obstacle, it's called obstacle preemption. Obstacle. So even in cases where the federal law doesn't expressly say we preempt, if the state passes a law that makes it impossible for the federal government to enforce a federal statute, that is implied preemption, or so-called obstacle preemption. But my point here is, in the cases that decide this preemption question, whether it's express or implied, in the area of medical cannabis laws, they have found there is no preemption. And again, I could go through and read you. I've got 7 or 8 highlighted quotes from that court case that but I will just refer you to the case. And again, the case is, I think I do have the site in here now. Yes, White Mountain versus Maricopa, 241, Arizona, 230. And it's a Court of Appeals case, 2016. And it provides just an excellent, multi-page analysis of why preemption does not exist in the area of the Controlled Substances Act when it comes to a state's medical cannabis laws. And so I say all that because I know that members of this body have concerns about doing things that are contrary to federal law. I mean, they respect the federal law. There's a supremacy clause in the Constitution. So my point here is to say there is no preemption here, which is in large measure why you've seen 36 states take advantage of this. And I just got to point this out, if I can put my hands on it quickly, because it is so fresh. Mississippi, okay? On January 19th, the Mississippi House of Representatives passed a medical marijuana bill that's a lot more liberal than this one, a lot more conditions, allows smoking. I mean, doesn't have all the things I've built into this bill. That House in Mississippi passed it 104 to 14. The state Senate passed it 45 to 5. Mississippi. So, and the reason for that is there's legal authority for states to act. There's no preemption. There is overwhelming medical evidence that cannabis can be a medicinal benefit in ways that, in some instances, pharmaceuticals cannot. And there have not been the parade of horribles or the societal consequences that I've heard some out in the lobby say will happen if God forbid, we pass a medical cannabis law and allow people like Margaret Richardson to access medicine safely and legally. I mean, so that's why you've seen this happening, and you've got other states right now that are taking this issue up as well, as we are. North Carolina, just to the north, is taking it up as well. Let's not be the 50th state to do this. I mean, we're better than that. I mean, and what we have, I mean, we just got done passing a repeal of certificate of need. And I chaired that subcommittee. And we heard testimony from DHEC and people that administer the certificate of need program. And I wanted to hear it. And some of them weren't in favor. And they gave the reasons why they weren't in favor. And I was fine with that because DHEC is an important player in this committee process. But how would you feel if the director of DHEC dispatched DHEC employees throughout the state to go to Rotary clubs and other civic meetings and make arguments against a piece of legislation seeking to repeal CON? Would you think that that was something that DHEC ought to do? Because I tell you what, that is what SLED is doing. SLED is sending out their sworn officers going to Rotary clubs, telling untruths about this bill. This bill doesn't even allow smoking, but they talk about smoking. They bring big blowtorches in and say this is what they use. I mean, the fear, the naked political posturing of it, it offends me that our state dollars and our law enforcement is going out across the state getting presentations on this. I welcome their participation in the committee process. I think the bill became a lot better by listening to SLED. But would we tolerate it if DHEC sent people out there to argue against CON? No, we wouldn't. That isn't a proper use of state money. They also, I'm sorry, you got me on this now, and
Well, I didn't get you on that.
well, no,
now.
I know, but I'm following through this train of thought because I got to get it off my chest. When we have these subcommittee meetings, and mothers with their kids, sometimes in wheelchairs, you know, just break your heart. They wait out in the hallway because SLED and the sheriffs took up every seat in the committee room, not to offer testimony, but to bully, to sit there glowering. Did you notice in the testimony that Margaret Richardson gave, you see who was right behind Margaret Richardson, staring at her, yawning during her testimony? That is not what they should be doing. All right, I'm done with that. Go ahead.
All right, so if I understand your argument, I'm going to put this in my words, and you correct me if I'm not saying it right. That even though this is a Schedule I substance, that in the Controlled Substances Act, it provides for states, your argument is that it provides for states to have different and perhaps conflicting laws from the federal law? Is that what your argument is?
Well, it's not even my argument. It's what the language of the Controlled Substances Act says.
I understand you've read the language, but again, I'm going to sit down here in a minute because there may be attorneys who would not agree with your interpretation of the text who want to take it up with you. It gets too nuanced for me to try to interpret that phrasing there, but that, I'm just saying, or trying to sum up, that that's what your argument is that the federal government has not claimed exclusive control of law
Right.
over Schedule I substances, that it provides for in the very act that states can disagree with them. Is that what you're, is that the argument?
That's what I'm saying, and that's what courts have ruled, okay? When confronted with this very question, Arizona, their medical marijuana law, there was an argument made that it conflicts with the Controlled Substances Act, and the CSA, the argument went, preempts the field, so Arizona could not act. Court rejected that argument and gave a very good analysis, and I would submit to you, find me one decision that's out there where a state cannabis law has been struck down because of federal preemption. There isn't one. There isn't one, because there's no preemption. But I make that, I go back and make that argument because, as I said about Senator Peel early on, I don't want to appeal just to your hearts, okay, or emotions. I want to lay down the solid framework for this bill, and that starts with what is our authority? What is our ability? What can we do?
To recap your statements here about the budget, I believe what you said is that in the last 7 years, every budget has included this proviso, and I'm assuming that what you're indicating is every budget and every continuing resolution, because we haven't had budgets in every 7 years, right?
We're operating under a continuing resolution now, and this proscription against using DOJ funds against state medical cannabis laws is part of that continuing resolution. I mean, it's not even debated anymore, Senator Anderson. It's sort of like some of these things that are in our state budgets. They're there forever. Once they're there, they're there. And they don't get debated. But yes, that is currently the state of the law. It's in part of that continuing resolution.
And so, if you take the language of that resolution, would I be wrong to say that the federal government's almost promulgating anti-commandeering language against itself? That we have this Schedule I substance, and now we're telling our own Department of Justice that no money can be appropriated to implement or enforce those laws. It's almost anti-commandeering language against itself. Is that?
And I think the reason for that is, and we've seen that recently with some of the legislation in Congress, they attempt to do things through the budget or do things through reconciliation because it's a lower threshold you have to clear. And so to get bills out of committee that would codify this instead of it being a budget proviso is apparently too difficult a lift to happen in Congress right now. But the fact remains that it is the law of the land that the Department of Justice can't challenge these state laws. They're proscribed expressly by Congress. Every year for the last, I think it's the last 7 years. I mean, it's been 7 or 8 years.
Well, Senator, I appreciate your response to my questions. I'm sure I'll have some more questions as we go along. And, you know, did you know that I did vote to pass this bill onto the floor, but did you know that I have indicated at every step of the way that although I'm open-minded about it, I reserved and still do, you know, the right to make a final decision after hearing all the debate, including the debate of those who are against this. I want to hear all of it. And seeing the final form of this bill after all the amendments are said and done with. And that remains my position, did you know?
You've always made that clear, Senator Anderson.